So if you could take a moment to add your contact information in the chat feature following the event, we will share that with all of the attendees so you can stay in touch. And also, if you have any questions throughout the program, feel free to add them in the chat, and we will have time for Q&A later in the event. So without further ado, I'd like to introduce our speakers for today's presentation. Catherine Taylor is the founder and owner of Taylor Legal, a law firm serving business owners and property owners. She started her law practice in 2004 after serving for 10 years as a senior assistant county solicitor for Howard County. Before joining the Howard County Office of Law, she was a senior associate in the commercial litigation department of the Baltimore law firm of Whiteford, Taylor, and Preston. She is also a CPA. Catherine loves working with business owners to help them protect the businesses that they created. Thanks for being with us, Catherine.
Okay, thank you.
And next up is Amy. Family Harmony. If you meet with Amy Lazarus of Providence Law Group, you'll hear those words because she wants to understand your family and help design a plan for you that will meet your goals when you are no longer around to ensure the family sticks together. After a successful high-tech sales and marketing career, Amy returned to law school so she could help families like yours. Having experienced her father's sudden death at age 46, she wanted to be sure to get the message out to as many families as possible about planning in advance for incapacity and death. When she's not working, she enjoys spending time with her family, her husband, adult children, and one grandson.
Oh, two now. We just had a baby granddaughter 2 weeks ago. I have to update that.
Oh my gosh. Congratulations. And two grandchildren. Reading, Pilates, and binge watching are some of her favorite leisure activities. I would agree with you there. And now I'm going to turn it over to Catherine and Amy.
Good morning. Thank you, everybody, for coming. So just a little background. Amy and I have known each other for years. We've been friends and colleagues. And we recently, I would say in the last year or two, have collaborated on several different client matters. And the way that would come to us is either I'm working with a client, a business client, and drafting, buy-sell agreement or operating agreement. And I say, is this consistent with your estate plan? And they're like, or vice versa. Amy might be working with an estate planning client that happens to be, either if it's a couple, one or the other or both happen to be a business owner. And, she will make sure that they have their business documents in place because those plans really do have to work together. So what we're going to do, because we feel like most people learn by hearing a story, and we have a kind of a hypothetical story. These are not real people that will kind of walk you through a couple of kind of drastic situations, but give you examples of not only what you need to do, but kind of why you need to do it. Because if you're like me, you always want to know the why. So we're going to start off with our story and, interweave within that some information for you to take away. Amy.
Hi, everybody. Okay, so here's our story. Jess Smith is a female business owner and entrepreneur. She's married with 2 children. She does a cursory search online for the name she would like to use for her company and another search online to see if the app she wants to create or anything similar is already in existence. She doesn't do any additional legal business planning, and she and her husband, Lonnie, have no estate planning documents in place. Jess is brilliant and she's very busy. She just doesn't think she should be spending her time or money doing any more than what she's already done. She gets a lucky break and a friend introduces her to an angel investor. She drives over to Northern Virginia, which is where they all are, right? And the investor agrees to provide some initial investment, enough for a business owner to hire a few people, including back end and a front end developer. Ecstatic, she heads home to Howard County, but is T-boned at a busy intersection. She's in bad shape and airlifted to shock trauma. She undergoes an 8-hour surgery and has months of rehab ahead of her. Catherine?
So after everybody makes sure that she's okay and she's she's going to survive and get through this, but it's going to take a long time. So the question is, what happens now to her business? She's been the only one operating her business. There's really, like many sole practitioners or solo entrepreneurs, there's nobody else that really kind of knows what's going on. So who can take over for her as it relates to her business interests? So spoiler alert, no one. And that's because she never established an entity like an LLC, and was therefore unable to use the LLC to name another entity member or another person who could act on behalf of the LLC that she created. So in addition to the personal trauma that she suffered, with regard to her health, her husband and children have to deal with that. But by the time she's back on her feet, the angel investor, as they all do, has moved on to a 25-year-old in Austin, Texas, who brought a similar application to market and is close to being a millionaire now. So a couple things that are important to know. One, an entity is a separate legal person. And that's what I think is very good to understand when you're looking at this kind of a situation. So before Jess created her legal entity, it was Jess, just her. When she creates a legal entity, she's the owner of that entity, but that entity is a separate legal, it literally is a legal person, a fictional person in legal, in the legal realm. That entity can do things, it has powers, it has authority, it can take actions as an entity. So what's important is that if if Jess is incapacitated, or if she would pass away, that legal entity exists and survives. Okay, that's number one. Number two, when we're talking about entities, we're generally talking about an LLC or a corporation. And there are lots of other types of entities, but for business people, as service professionals in particular, those two are the main types of entities that you would create. If you haven't created an entity and you are curious about what type of entity to form, it would be a great idea for you to have a conversation with a lawyer and or your accountant. There are definitely liability, tax reasons, administration reasons, legal reasons, all sorts of reasons why you might want to form one or the other. Okay, so for purpose of this, we're going to be primarily talking about an LLC. Now, the third thing to remember is that once she forms the entity, it doesn't stop there. There are some other things that she needs to do, which is where I see a lot of people making this mistake. They form the entity and you're busy, you're operating your business, and then you fail to do some of these other things that helps you to protect your entity. So those are kind of some background tidbits that you really need to know as you explore these issues. All right, so Amy.
So what happens to Jess's assets while she's incapacitated? She's in the hospital now and she's unable to manage her assets. Most of us think initially that surely her husband will be able to step in and do whatever needs to be done related to her assets, right? That's what most people think. That is not true. Any asset in Jess's name only cannot be managed by anyone but her. Her husband would have to pay an attorney. I don't do these, but they're called guardianships. And it costs around maybe $5,000 to go before a judge and request that the judge name the husband as her guardian so that he could manage her assets. And sometimes other people want that role. In Jess's case, it's her meddlesome sister who wants to be the guardian, and it's up to the judge. There are no guarantees if you haven't got validly executed documents stating who you want to do that on your behalf. Sadly, after about 2 months in the hospital, Jess passes away. The business is already lost. So what happens now? Can Lonnie, her husband, just get her assets now that she's passed away? Nope, he cannot, because there was no method in place to do that. There was no revocable living trust that he was a co-trustee on. and there was no accompanying pour over will for anything that they missed. So any assets in Jess's name only, and some will likely be in her name only with no other legal way to get them into another person's name. So they'll have to go through what we call the probate process. And the probate process gets kind of has bad reputation, but really, it's lengthy, time consuming, and expensive. It often makes heirs really angry. They had no idea, they don't understand it. But the idea behind probate is very good. The government wants to be sure that when there's an asset in one person's name, it isn't taken or somehow scooped up by someone who's not the rightful heir. So the probate process is the process by which that asset goes titled in one name to legally titled some other way. So the idea behind it is good, but we don't need that process if we get our documents in order and we name who we want to receive things. So typically death probate takes 12 months is the fastest I've ever been able to do it. 18 months is much more common. It can be quite expensive. A lot of times people will have assets with beneficiary designations. That's one way to pass outside of probate. And for some families, that's a very good way. What you have to know about beneficiary designations, though, is that they happen right away, right? So if there's any reason why someone shouldn't get a whole bunch of money all at once, you don't want to leave it by beneficiary designation. You might want to consider a revocable living trust where they're not going to get it all at once. Some reasons why you might not want them to get it all at once. What if they're in the middle of a terrible divorce, right? And all of a sudden there's this influx of cash that's in the joint bank account. It's what we call commingled. Now we have a problem. And there can be other reasons as well. So to administer, let's just say there's a $450,000 house and that's the only asset that's a probate asset. That's probably you're gonna pay somebody like me probably around $15,000 to $17,000 to get that through probate. And if there are business assets and if the business is appraised or valued and it's worth something, those costs are likely to be much, much higher. So just to emphasize what Catherine said earlier, it's very important that your estate planning attorney and your business attorney, number one, that you have both of those, and number two, that they talk to one another, right? So that those documents work in concert. Catherine?
Thanks. So just to kind of follow up on what Amy was saying, a person's interest, whether you own stock in your corporation or whether you are a member in LLC and you own an LLC interest or a membership interest as it's called, if there's no other indication in any documents that dictates where that interest goes in the situation where you're incapacitated or you pass away, then that ownership interest, the stock or the LLC interest, becomes part of your estate. And just like Amy said, then you've got to go through the probate process with that LLC interest, which can be a mess because, as I said, the LLC is a separate entity. If it's sitting in an estate, then legally the personal representative of that estate has the right to run the business. So, and I'm going to give you a little example. So, a number of years ago, two very young men and very fit young men, and I say fit because it kind of goes to what happened, came to me because they were starting a fitness center, and this was pre-COVID, and they were doing everything right. They were, they made sure that they had me draft an operating agreement for them. They, put the right documents and contracts into place, for hiring their employees or independent contractors. And they had me review the lease and all that. Long story short, about a year after they started the business, one of the young men passed away very suddenly. It was a shock to his family. It was a shock to his partner. It was a shock to me when I got that call. So what happened then, fortunately, is they did have an operating agreement that essentially said that, the member, the surviving member could essentially take on, the operation of the business. If they had not had that in place, then the personal representative would have essentially become, their surviving partner's partner in business, which would have been very complicated because this was the sister of the young man who passed away. So that was, it's interesting because for so many years, I've kind of lectured on that. You need to have these documents in place. And that was really the first time that something very sudden like that happened to one of my clients. And, it was a shock, but fortunately, they had some of these documents, these necessary documents in place. And, the business is still surviving. And, they went through a tough time during COVID, but, he's still running, the surviving partner's still running the business. So, so that was all, that was all good for that part of it. So, okay. So what if let's, kind of skip back, rewind. What if we give Jess and Lonnie a do-over? We don't always get do-overs, but let's give them a do-over. So what would they or should they have done if they were doing things properly? So the first thing is that Jess decided to consult with moi, a business attorney, and to discuss what type of entity she should form. And I didn't say whether she should form an entity or not. I can tell you that there has been probably one situation in the 15 years that I've done business that I've suggested that it might not be necessary for somebody to form an entity to operate their business. But otherwise, almost to a person, I highly, highly recommend that you form an entity. Again, whether it's an LLC or corporation. But that's what your business attorney and also your accountant will help you decide. Again, there are tax reasons why you might want to form one or the other. There are administration reasons. There are lots of reasons that kind of go into that decision. Okay, so so Jess decided that she was going to form an LLC, which was a great decision, and I suggest that Jess's husband Lonnie could be a member of the LLC, a member being an owner. Doesn't have to be, but in this situation, we decided it was a good idea. So both of them are members of the LLC. And it's great because Lonnie is the CEO of another company. And so he understands kind of, how to run a business. So they set up the LLC with both of them as members. And because they're both members of the LLC, they both have the authority to act on behalf of the entity. Remember, the entity is a separate person. So all their business documents are created. They did create an operating agreement for the LLC. If this had been a corporation, they would have created bylaws. They would have had their stock certificates issued. They would have prepared a stock ledger. They would have a buy-sell agreement or a shareholders agreement between the two shareholders, all that in place. LLC is a bit easier. They have an operating agreement. So that's all great. They also, smart as they are, Jess and Lonnie reach out to Amy, an estate planning lawyer, because they realize, their assets are increasing. They've got this business now, and they really need to talk about what would happen if either or both of them, something happened to either or both of them. So after all the estate planning documents are created, which would consist of, as Amy said, a pour-over will, irrevocable living trust. There are other documents such as a healthcare power of attorney, a durable financial power of attorney. I'll let Amy talk about some of those in more detail. And then each of them name the other as personal representative of their estates and co-trustees of their joint living trust. So now, if in the situation where Jess becomes incapacitated, let's say she's still alive, who can step in for her as it relates to her business? Her husband can, because he's a member of the LLC. So he has all this authority to do what Jess could have done. Let me just state, I don't always suggest that husband and wife become members of LLCs. for various reasons. And so if you have one spouse or the other who is the sole member in an LLC, you can accomplish really the same goal as having somebody else have power to act on behalf of the LLC in your operating agreement. So you don't have to have both spouses be members of your LLC. So the good thing though, Lonnie is the other member of the LLC. He can step in and essentially act on behalf of that entity. He reaches out to the angel investor, explains what's going on, and knows that Jess would want him to move forward with the business. He signs the documents on behalf of the LLC that were sent by the angel investor. They get the investment, and the 25-year-old in Austin is going to have to come up with another idea. All right, Amy.
So what happens to Jess's assets while she's incapacitated outside of what, in this redo, outside of what Catherine just mentioned for her LLC interest? Let's say these are her personal assets, right? The whole separate person idea. Well, now that she's named Lonnie, her husband, as her durable financial power of attorney, he's therefore now able to stand in Jess's shoes and act on her behalf for any assets owned in her name only. This is while she's incapacitated. Maybe this is her retirement account. Maybe the investments in her retirement account right now are the wrong investments. This is a terrible example, but let's say at the beginning of COVID, let's say all of her retirement assets were in airline and hotel stocks, right? That was not going to be a winning formula. You would have wanted to get in there and change those investment choices, especially if for months and months, she's not going to be able to do that. So that's just one example of an asset that would clearly have to be in her name only, and perhaps something would need to be done with it while she was incapacitated. The great thing about it is no court involvement is required now, right? When you take the responsibility to put things in writing and validly execute them, now the court isn't needed to make sure the right person gets that job, right? So you have a lot more control. What happens to Jess's personal assets when she passes away? Again, these are assets in Jess's name only. Well, it depends. So many of these things, it depends. But to the degree that the asset were retitled into the name of a revocable living trust, and if there was a co-trustee and it was her husband, then he now has control over all of those assets that are in the living trust, and he can help out with them during her incapacity and at her death. Again, no court involvement is required at her death for those particular assets. There's other things to consider as well. For example, if you're a business owner, let's say it's you're married, let's say it's a husband and a wife, and the husband is a business owner with another male partner. Okay, so now what do we do? So often I'm able to do a joint living revocable trust for long married couples who have children in common. That's kind of an economical way to do it. We may or may not want to do that depending on the decisions that we're making with the business attorney like Catherine. So you want to make sure similarly that the business partner doesn't end up being a trustee of the trust, right? So that you just have to make sure, it's a little bit of a minefield. You want to make sure you kind of walk through all the steps and make the best choices so that, for example, the buy-sell could pay to the trust as an example, and then the surviving trustor would be able to get the money from the business and move on. So that's all I had for my formal comments. Catherine, I don't know if you want to add anything in terms of just kind of wrapping it up.
Yes. So how does this happen in real life? So, we kind of laid out what should happen. And as we all know, in our businesses and in our personal lives, many times what should happen just because of life. I always like to say life gets in the way of life, right? A lot of times these things don't actually happen. So many times what does happen is either there will be a situation, which kind of is a wake-up call, or maybe even a situation where, let's say, take Jess and Lonnie. They, they got the business and everything, but they also have little kids, and they realize they really need an estate plan put in place because they want to make sure primarily that their kids are taken care of and their assets go to their kids, etc. So they go to Amy, and in the course of the wealth of information that Amy is going to get from Jess and Lonnie, she finds out that they co-own a business. And then she asks them if their business documents are in place. And that's kind of, many times how I or another business attorney would get involved. It's interesting because many estate planning lawyers don't also do business work, and vice versa. I mean, you'll definitely find lawyers who do both, and you'll certainly find law firms who do both. But usually the lawyers who are, estate planning attorneys really concentrate in estate planning, and then, business lawyers will essentially concentrate in business. So it's, unfortunately, you many times will have to talk to two different people, but it's certainly well worth your time and investment early on. So I'm going to give you an example of another example of a situation that Amy and I both worked on. So an older couple who had run a business for many years came to her for her to do their estate planning, and which was fabulous. They were doing the right thing. In the context of her drafting their estate plan, she learns that they have this business and highly recommends that they talk to a business attorney to make sure that all the business documents were in place. And she referred them to me. This couple, again, they ran their own business for many years. One of the wife was an accountant. The husband, was a college professor at one point, and, very competent, bright people. And they, believed over the years that they could do all of this business stuff and the business documents themselves, which they did. And, but they didn't keep up with it. They didn't keep up with it over a number of years. And then, kind of what happened is at, 10, 15 years later, they've got stale business documents that don't reflect what's actually happened to the business. They actually had one of the documents actually mixed up who was the owner, who the stockholders were. And that could have been a real mess, if something would have happened to one or the other of them. So when they came to me, I looked at everything. I said, listen, this is what you need to do. You need to bring your this was a corporation. You need to bring your resolutions for your shareholders and board up to date. You need to bring your stock certificates up to date. They couldn't find a stock certificate. We did a loss certificate affidavit. I mean, there's all these kind of things that you can do to make sure you bring everything current and make sure everything is in a good situation now. So it's never too late to get things right. So we got things right for them. Lo and behold, they start talking around to other people in their industry, and they find out that their business is actually worth something. It's actually worth a lot. And they want to sell their business. Thankfully, when the proposed buyer or the buyer's attorney and the buyer's bank, who's financing the purchase on behalf of the buyer, go to the sellers and ask them for their articles of incorporation, their bylaws, their minutes, the bank resolutions. We've got all that because they brought it all current. So they were able to pass this on to the buyer, the buyer's bank, and show that this entity was, in tip-top condition, let's say. And that just made the process of selling a whole lot easier. And I raise that example because there's another thing to consider, that many times you might not think an operating agreement is all that important, or a buy-sell agreement is all that important. But if you look down the road, you realize that it certainly can be important. Many banks now, when you go to open a business account, will ask for an operating agreement for an LLC. They didn't used to do that. The banks are getting much more strict. I think we've got somebody from Severn Bank here as to who can actually open an account. And if it's a company, if it's an LLC or corporation, that bank has to know that it's a real live entity, a validly created entity and a valid operating entity. Lenders, if your business is going to go, I don't know if any of you sought out PPP loans, but you probably had to go dust off your governing documents for your business, because that lender is not going to lend your business money if your operating documents, your governing documents are not up to date. So there's a lot of other reasons, really just kind of beyond, kind of the relationship among the owners and then even their families, that all of these things are important to have in place. And, the good thing is that once you put these documents in place, it may be a bit of an investment of your time and funds, but you don't have to change them all that often, and so, once they're in place, you can sleep at night, you know that everything's taken care of, and you're not really going to have to worry about kind of the what ifs. And, that was the name of this webinar, kind of what if. Well, if you address these things, then the what if, you don't even have to worry about. It's not even a question you have to ask yourself. So, all right. So at that, I think we'll open up for questions. I know that Kim had a list of, both of us mentioned some documents that you might want to have in place. Kim has a list of those that she's sharing her screen so that you can see. And then Kim will also email this to you guys afterwards, so you don't have to try to take notes or take a screenshot. But yes, let's open it up to questions. If you have a question, you can unmute yourself and we'll just go from there. Jean, I think you had a question. There you go. You're unmuted.
Yeah, I actually put them in the chat there, just,
Okay.
and again, from the, I am a banker, I've been a banker for 40 years, so I certainly understand most of these things, but my husband and I have a small business, and I'm always interested to hear perspectives.
Right.
So, and we do have an operating agreement for our small business, but listening to you now, I'm like, I maybe don't have enough in that operating agreement. It's just something that I kind of, self did, on my own, but created that myself. And interestingly, it was when I was at a larger bank, they required it, but Severn does not currently. And, but it's a good idea, as you mentioned. So I was just wondering if there's just a general idea of what should be in the operating agreement. I think we just put in there who the principals are. We all have, it was really, really very, very basic.
Right.
And then the other question that I had that I put in the chat there was, how often are business documents every 5 years and personal documents every 3, or vice versa? What's a general guideline for business and personal document review, legal document review?
Okay, so I'll address the items that I can address, and then I'll hand it over to Amy. But in terms of what items should be included in an operating agreement, it's a very good question. Many people, because I totally get it. I run a small business myself. You're always trying to save money. You don't want to have to pay a lawyer to do things that you feel like you can do yourself. I have a YouTube channel, and I do some quick videos on just like questions that people ask. And one of them is, do I need an operating agreement? And generally what I say is, if you're a sole member LLC, it is not as important to have an operating agreement, because what an operating agreement is primarily is it is an agreement between the members of the LLC, the owners of that business, just like a shareholder agreement is an agreement between and among the shareholders of, or the stockholders of the business. So, if you're sole member LLC, then basically the agreement is with the LLC and yourself. So it's not necessary.
But didn't you say that's where you would put, I think if I heard that correctly, if you were sole, you would put who the continuation piece. Sort of.
Exactly.
Okay.
So what I have been doing more often is making sure that not only does that operating agreement account for, the relationship and the powers and obligations as between the members themselves, but what happens if one or the other member, or if it's a sole member, what happens if that person passes away? So Amy and I, about a year or so ago, jointly did some research into whether or not an LLC interest could be the subject of a transfer on death directive. And our conclusion was that it can. And so what I've been doing lately is when I draft an operating agreement, whether it's a sole member or, multiple members, I create transfer on death directives that are kind of like a beneficiary designation, if you will, that basically states, let's take Jess and Lonnie. The TOD directive would say that immediately upon the death of one, that all of the interest in the LLC transfers to the other. So you don't have part of the interest going into the person's estate, let's say. Because even though, let's go back to the Jess and Lonnie example, even though Lonnie was a member, without that transfer on death directive, Jess's interest goes into her estate. So even though he has the authority, he still has to kind of deal with the kind of estate issue. But if you create that directive that says what happens to that person's interest should they become incapacitated, die, then you've covered that eventuality. A couple other things that can be in operating agreements, which I think are very, very important. So let's say, well, it could be Jess and Lonnie, or it's, them and a couple of other people who are forming a business. Let's say that one of the members of that LLC is going through a divorce, and then ultimately becomes divorced. Well, when you're, in a divorce situation, there's this concept called marital property. And you're not going to get into that because that's not what I do. But in a nutshell, the LLC interest owned by a divorcing spouse could be considered to be marital property that, needs to be looked at to determine, what's going to happen to it in the situation where there's a divorce. So that's something that you can cover in an operating agreement. You can cover a situation where one of the other members becomes incapacitated, one of them goes into bankruptcy. So in essence, that operating agreement can almost like become the estate plan for the business. In terms of how often do you recommend reviewing personal and business documents? I'll let Amy address the personal. Business documents, it should be those documents for living, breathing documents. I think there should never be a situation where you put them aside and say, I'm not going to look at them. Now, that doesn't mean that every month you have to take them out and say, oh my God, do I need to revise this? But I think at a minimum, every year you should, kind of sit back, if it's at the time that you're providing your financial documents to the accountant for your tax returns, if you just have a quick call with a business attorney, just say, hey, this is what happened over the past year. We're doing some things differently. And then, you can be advised as to whether you need to change those agreements or not. If nothing big changes in the business, then you really don't need to change those documents. One thing to note, however, with a shareholder agreement and an operating agreement, every single shareholder and every single member of the LLC has to sign that agreement. Okay. That's something important. So, if you bring somebody on as a member of the LLC or as a shareholder, then that person has to sign the agreement. All right, so I think Amy can address how often you need to review your personal estate planning documents.
Yeah, of course. So it really depends, right? It depends on the age of the person and their life situation. What I usually say is, and this is just a guess, right? But if you're maybe 65 or over, maybe you come to see me every 3 years, you pay for an hour of my time and we do a quick review. That review includes, have there been any changes in the law that might necessitate changes in your documents? And it also includes things in your life. Maybe somebody you named a successor trustee or a personal representative you no longer trust or no longer have a relationship with, and you need to change that. Most often when people do come back like that, there are very few changes that need to be made, if any. If you are, younger, maybe in good health, maybe you can extend that to every 5 years. But it is really important. There are big changes in the law that happen, and your documents may not work the way that you think. And I often see very old documents, maybe from the 80s, right, that required a split in a trust, and where there is no split needed now, right? Because right now the tax situation doesn't require that split happen. And so what I often do is I there's one way that you could try to get out of that, and it's by petitioning the court and having all of what's called the qualified beneficiaries sign. It is expensive, time consuming, and all of those qualified beneficiaries may not want to sign. And if they don't, it is not going to work. So you definitely don't want to get all your documents done and put it under your bed, right? Because when they come back out, boy, the family is really not happy with what they see. And a couple of changes that have happened, in the last 5 years or so, we now have a law that controls digital assets, right? We didn't used to have that. So we now, most states have it. I think 32 states have it. It's a access to fiduciary digital assets law. So that's now in all of my documents. Another thing that changed, I think in 2015, is the Maryland legislature added something called a statutory power of attorney. And we can talk more about that in terms of what else you need and how all that works.
So I'm actually looking at the chat questions. So Stephen Conti has a question, and speak up if you have a question and it's not in the chat, but I'm just going to go through the chat questions. So Stephen, you said, what are your thoughts on forming a business succession plan? So yeah, that's a great idea. What is a business succession plan? It really is kind of a two-pronged process. And what I've described is really kind of the legal and let's say the governing document process for the actual kind of legal entity of the LLC. But in addition to that, it's always a great idea to have procedures in place that are written down that, if something happens to you and somebody has to take over your business, they know what to do. They know where the payroll documents are kept, whatever. They know who to pay the rent to. For your lease. So, a lot of that is kind of almost common sense. Like, okay, if somebody needed to come in here and run this place for a week or, a month or a year, how would they know what to do? You could have a file in, just online that somebody has access to that just has kind of like all your contacts, for your vendors, your payroll company, your accountant, what have you. So that's part of creating a business succession plan that really isn't legal in nature. It's very practical in nature. Another thing, I see we have an Edward Jones person on the in the webinar. Another thing that you can look at is getting what is called key person insurance, which is essentially, if something happens to if a key employee or you as the owner die, then that policy could perhaps fund a takeover, a purchase, or continuing operating funds for the company. I mean, there's all sorts of ways that you can account for that. So it's really, again, it's a two-pronged thing. You got to make sure all your legal stuff, that's why I call it legal stuff. That's a technical legal term, is in place, but also all your practical stuff is in place. And if all that is done, then again, you're just going to feel so much better about your business kind of on a day-to-day basis.
So is the succession plan part of what you are able to provide your clients, like at least a rough outline of how to approach it? Because I've heard this in a bunch of webinars, like when the pandemic hit, like you don't know if your business is going to survive, plan for it, or maybe you don't want to work forever. How do you get out of your business when that time of your life comes and you're ready to not do the day in, day out work?
Right. So there are a couple things there. So again, I'm talking about the practical stuff and the legal stuff. So as regards the practical stuff, I mean, I can definitely, and I always do give my clients some ideas as to the things that they can do. In addition, I mean, little things like making sure somebody has access to all of the logins to all of the software that your business uses on a day-to-day basis. That's like,
I'm just going to jump in real quick. You're going to want to be sure that your power of attorney allows them to do that. So it's not a federal offense. So you definitely want to be sure that you have that digital asset language in your power of attorney, and then you're good to go.
Got it. Okay. But as a practical matter, a lot of times it really depends on your business, and there are many places you can go to, Google business succession plan and get like kind of the practical aspects of what you should be doing. So Stephen, in your business, you're a massage therapist. you have clients that you would want the person to be able to contact, right? You probably, I don't know if you rent commercial
I do, yes.
space, you would want to be able to make sure that whoever's taking over knows who the landlord is, knows who to pay the utilities to, just all those kinds of things that are really just almost like common sense, but it's all in your head. But
So
it might not be anywhere somebody can get to it if you can't get to it, if you're not able to.
Okay, so I'm understanding it from at least your take on it is more of a planning and not a legal thing. Like it's more just best practices to have this available. And then
That
what you said is
exactly.
there needs to be language in the power of attorney for the digital portion. So like, does that mean my wife, for example, who we have listed on the power of attorney,
Right.
does that mean that then, because I'm a sole member LLC, so I
Correct.
don't have anyone else that's going to take over. Does that mean that I should, well, I know I can't give advice, but if it would make more sense to put her on there so she could just kind of dissolve everything and file the articles of dissolution?
So, right. So it's getting a little complicated. I wouldn't necessarily say you want to put your wife on the LLC or make her an LLC owner or member just for that reason. But there is a way with the power of attorney that you can give her the authority to act on your behalf as it concerns not only your personal assets, but as it concerns your business. Because if she steps into your shoes, then you as an LLC member have the ability to take certain actions on behalf of the LLC. If the power of attorney gives her that authority, then she can do that on your behalf.
Remember too that assets are there's kind of a dividing line. You're incapacitated but alive,
right?
Or you've passed away. Okay, so different documents operate at different times, right? And so, and that's a little bit complicated if there's a trust involved. But basically, if you add what Catherine is talking about, which is like real life practicality, right? And then you take the business entity planning and the estate planning, and you put them together, that is your succession plan. That's really what a succession plan is, right? You want to take care of the business, you want to take care of your family, you want to make sure all the legal documents talk to each other and they work together. And so that's why it's so important that, whoever those attorneys are, they're talking to each other.
Right. So I have a question here from Jean. What are your thoughts on placing assets in business names versus personal names, like, for instance, vehicles, equipment, property? If it's a business asset, it should be in the business name. If it's in your personal name, it's not owned by the business, it's owned by you personally. Quick example. Right now, I'm dealing with a sale of the business. I represent the buyers. So one thing that they're going to be transferring is the trade name to the business, because the trade name is different from the actual formal corporation name. Well, it just so happens that the trade name was put in the name of the owner of the corporation's husband. Again, this is a guy who, tried to do a lot of this legal and accounting work, kind of for himself, and thought that was the best way to do it. So the trade name is in the name of him personally. So when we were drafting the agreement, he was part of the agreement because he owns the trade name. So he has to transfer that trade name. They kind of pushed back and they said, well, he's not an owner of the company, he doesn't need to sign the agreement. I'm like, no, he does, because he's an owner of that asset. So if it's a business asset, it should be in the name of the business. No ifs, ands, or buts about it.
Yeah, I have a lot of customers that they're maybe buying a vehicle and they can't decide whether it should be in my name and I guess that also gets into insurance reasons. And then if you have an accident with the vehicle, there's a lot more to that question than just a simple question.
There is, and let me tell you. So I find a lot of people, and this is a little off topic, but just really quick, a lot of people say, oh, I'm going to buy the vehicle and run it through the business. Well, if you have a CPA, an accountant doing your taxes, you're probably going to find that, the entire cost of that vehicle isn't necessarily being paid for by the business. There's going to be a proration of, the deductible costs based on your personal and business use. So, there may be other tax reasons for having the company buy the vehicle as opposed to a person. In that situation, you can deal with the situation. I mean, if it's just a personal vehicle that you own, it can be in your personal name or your business name, it doesn't matter. If your company owns a fleet of vehicles that your employees are using, by all means, they should be in your business name, because if there's an accident, the owner of the vehicle is going to be sued, believe me. And if you're the personal owner of that vehicle, then you're going to get sued personally as opposed to the business. And the whole reason you set up a business is to have that limited liability. So real quick, we've got a few more minutes, and this is actually a very good question. So I'm going to go over this and then we'll probably need to wrap up. But before we do, if you have any other questions, we'll give you information at the end, how to get a hold of us. But forming a business in Maryland versus another state. If you're an LLC, if you're forming an LLC and you have you live in Maryland, your principal place of business is in Maryland, you're not going to be doing business all over the country, I find that it is just as good to form in Maryland as opposed to Delaware. If it's a corporation, a little bit different analysis goes into play. If you're hoping to get venture capital, angel investors, eventually go public, you might want to form your corporation in Delaware. Otherwise, it's really easier in many ways. And I don't really think that the income tax situation is that much different. Again, an accountant would need to look at that. But if you form the business in Maryland and then you do business in another state, you've got to register to do business in that state. On the other hand, if you form in Delaware, you've still got to register to do business in Maryland. So, it doesn't totally relieve you of these filing obligations. But that's something you should definitely talk to an attorney about, because there are a ton of other factors that go into that equation. Amy, you have anything to follow up with?
I don't think so. Good questions. And obviously there's a kind of a lot more that goes into it in terms of the things that you're going to think about and understand. So, reach out if we can help further, and thanks for your time today.
And thanks. And again, Kim's going to send out the list of documents and our contact information. So feel free to contact us. And if you have any questions, we'll go from there. It's good seeing all you.
Thank you.
Mm-hmm.
Great. Thank you so much. That was
Yeah.
such a great presentation and wonderful questions as well.
Yeah.
This has been a really great session. So as was said, we are going to send out the list of documents along with their contact information probably this afternoon or tomorrow morning. We also will have a recording of the video. So if you want to go back and review anything, you're welcome to do so. We'll send you a link to that.
Oh, that's great.
Yeah.
Super.
So we do hope you'll tune in for our future webinars, and our schedule can be found on our website at centralmaryland.org. Just a couple to highlight real quick. Tomorrow morning at 9 a.m., we will have our Membership 101 session where you can learn all about the benefits of being a chamber member. So if you have not yet joined, feel free to join us for that free event. On May 11th, we're hosting an in-person networking event at Nuke's Eatery. On May 13th, we're hosting an economic update with Tom Barkin of the Federal Reserve Bank of Richmond. May 20th is our Business Leaders Luncheon with our special guest, Lieutenant Governor Boyd Rutherford. And please save the date for one of our most wonderful events of the year. We will be having our Spirit of Community Awards on May 24th. Again, we'll share a link to the video and the documents with you as soon as we can. But thank you again to Catherine and Amy for such a great presentation. I encourage you to reach out to them to schedule a one-on-one if you have any other questions we didn't cover today. So we hope to see you soon and have a wonderful day.
Thank you.